A very good afternoon to all our participants. We thank you for joining us on this special webinar on a clinical analysis of recent Supreme Court judgments in GST and IDT with none other than Advocate Rohan Shah. Sir is one of the top lawyers in the country, well known for his expertise on advisory, policy, and controversy issues related to domestic and international taxation in India. He represents cases before different forums in relation to GST, customs, service tax, VAT, income tax, and transfer pricing issues. He has also appeared in various bilateral investment treaty arbitrations. He has been repeatedly recognized as one of Asia's and India's leading tax controversy lawyers in chambers and partners in Asia Pacific, International Tax Review, World Tax, Benchmark Litigation Asia Pacific, and various other publications. He has also been a member of the expert committees formed by the Indian Ministry of Finance and Ministry of Commerce on issues related to the introduction of presumptive taxation for the gems and jewelry sector, the introduction of goods and services tax, and the export of services. Thank you, sir, for taking out the time to impart your invaluable wisdom to all our participants today. Before I hand it over to Taxsutra's group editor, Arun Giri, who shall set the context for today's session, I would like to take the opportunity to apprise you all that depending on the time availability, we will try and host a dedicated question and answer session. For this, you may post your queries in the Zoom chat box. With this, I now hand it over to Arun.
Thanks, Tanay, and I won't take more than 30 seconds. Rohan Bhai says that he has a conference at 5:30 sharp, after which he has to watch a match. So everything has been tailored so that he can start. You know, he's a cricket buff. He's played alongside Ravi Shastri several decades back. So the fact that he couldn't make it to the national cricket team is the tax profession and the legal profession's gain. We have 4 important Supreme Court judgments, Supreme Court High Court judgments. 2 of them came back to back. We were all pressing the Supreme Court website, refreshing every 10 seconds for the Mohit Minerals ratio, but the secondment one came first. So we had to, first dispose that off. Then come to the Mohit Minerals one, both important, one on secondment, one on IGST, on ocean trade, with big, some important observations on GST Council recommendations, plus the Gujarat High Court judgment on land, development, 2/3, 1/3, and so on and so forth. But I'm sure that everyone wants to hear Rohan Bhai first, upmost on possibly Mohit Minerals, then secondment. Rohan Bhai, there have been a lot of views, a lot of articles, a lot of punditry you're hearing from one of the finest tax and legal brains in this country. Rohan Bhai, over to you.
Thank you, Arun. And firstly, compliments to you and your team for the excellent coverage that you all have had, both in terms of timing, the editorial content of all of these judgments. And, I, like many others, I think I take my cues on what is the latest really by following Taxsutra. So on behalf of the whole tax community, many thanks. And let's jump straight into, Mohit Minerals. And when I use the word, let's jump straight into the Mohit Minerals, I think it's the one judgment where, lots of headlines have been fostered because of the issue of whether states now have an independent ability to legislate in the context of GST as far as SGST is concerned. And I think many state ministers with varying degrees of intensity are sort of saying that this is something which probably is possible. And I think it's very important, given the overall theme of GST, one nation, one tax, one unified market, as to what this judgment actually does say. I know several of you have had the benefit of quite detailed analysis of this judgment. I'm going to sort of focus my lens on 3 or 4 critical issues, uppermost being the comments and the observations in terms of the constitutional provisions and the role of the GST Council. So if we start our slides on the Mohit Mineral issue, I've, of course, had one of my colleagues who's made a very assiduous analysis of this. And if Arun can share this presentation, I'm sure all of you will benefit from it. But let me sort of place two situations in context. One, what was the controversy in Mohit Minerals? And the issue really was in the context of the fact that there was a transaction for the supply of goods on a CIF basis. And this judgment is only in the context of CIF transactions. It doesn't apply to FOB or any other format of transaction. That in the context of this CIF transaction, primarily there was going to be a levy of IGST besides the basic customs duty. A IGST would have been attracted and that would have been discharged on the import of the goods. Since the transaction was on a CIF basis, in the taxable value of the goods, inherently there would have been included the transportation or the freight charges because the transaction was CIF. Therefore, freight was inherent. And the aspect which came up is that while undoubtedly there is a levy on the goods, and that process of levy includes the levy of IGST, is there a separate levy sustainable in the context of services, and whether the transportation is a independently taxable service? And if taxable as an independently taxable service, do we have a recipient of the service in India, namely the importer? And in the context of the service transaction, can we reach two conclusions? One, that there is a recipient of the service in India. There is a taxable transaction for provision of service. And if so, should this now be leviable under Section 5(3) to tax on a reverse charge basis in the hands of the importer, right? And the provisions which were really up for scrutiny were serial number 9 of notification 8 of 2017, which prescribes the rate of 5% on specified services, including the transportation of goods in a vessel from a place outside India to a customs station in India. What was also up for consideration in terms of Section 5(3) was serial number 10 of notification 10 of 2017, in terms of which the recipient was assumed to be the importer under Section 2 in sub 26 of the Customs Act, and whether such recipient, namely the importer, would now be liable to the levy on a reverse charge basis. This was the focus of the original controversy. Of course, as the matter went up to the Honorable Supreme Court, the issues which were finally looked at by the Honorable Supreme Court were much wider than just this aspect of the controversy. So if we go to the next slide, and we've listed here what were the relevant aspects for examination by the Honorable Supreme Court. And I must say that one of the great pleasures of being a lawyer is really the ability to read the judgments of Justice Chandrachud, the ones he's authored, because the manner in which they've written and the sequence in which they are written, I think is really an education for everyone. And the fact that he can do this on a wide variety of issues on, constitutional law, public law, private law, taxation, I think is just truly remarkable when somebody like me reads his judgments. Now, if we see, therefore, the issues which were isolated for consideration, some of these issues automatically were meant to be issues of a larger importance and interpretation, which were consciously taken by the court. So if we see, the first issue is whether the recommendations of the GST Council are binding or are not binding. And if so, what is the extent to which they are binding, right? whether the impugned notifications suffer from excessive delegation, whether any charge has been separately created for the taxation of ocean freight transactions, whether the application of 5(3) would create a levy and would create a levy on a reverse charge basis. And the situation is, could you take what is essentially an embedded service component of a transaction for the procurement of goods and separately charge the service transaction, even though you had already charged the transaction in goods? Therefore, could you take one element of the pre-tax transaction and again seek to bring it to taxation? And it is in this context of this query that, again, the honorable judges consider the composite supply aspect and come to their ultimate view in terms of the taxability. But let's sort of proceed. And as I said, there are sort of series of slides. But before we go to these, I think it's very important to set context of the constitutional background in the context of the inquiry which was made. And let's sort of understand that Article 246, which was the previous formulation, which applied in the context of all indirect taxes, and where, as all of you are aware, we had a list 1, where it is the union or the parliament which has the ability to legislate. We had effectively the list 2 or the state list, where the legislature of the state would legislate and have exclusive powers. And then we had the concurrent list. And in the context of the concurrent list, there is an ability for either the parliament of the union or the legislature of the state to make laws. But 254 then works out the primacy in the context of the concurrent list, to the effect that if the parliament of the union effectively legislates, then that will have primacy over anything which is effectively legislated by the state. So if we see the general scheme, 246(1) was the recognition in the constitution that parliament has the exclusive powers as regards list 1, the union list. If we go to sub 2, really we should start that process by first looking at sub 3, because 2 begins with a non-obstante saying notwithstanding anything in clause 3. So it's important we first understand the scope of 3. 3 effectively says that it is the legislature of any state which has the exclusive power as regards list 2, which is the state list. And if we look at sub 2, then the situation is that as regards anything in the concurrent list, which is list 3, either it is parliament of the union or it is the legislature of any state. The inevitable question would be, as far as the concurrent list, what if parliament legislates in a manner contrary to what is state legislation? And the answer is provided by 254(1), where the situation is to say that if you have a situation where a provision by the legislature of a state is repugnant to any provision of law made by parliament, then the law made by parliament will have primacy, it shall prevail. And to that extent, the state law shall be considered, to the extent of such aspect of repugnancy, be considered to be void. 254(2), the more special provision, that again in the concurrent list, if something is legislated by a state, it is reserved, the president gives his consent, then qua that particular state, that is what will prevail. But that doesn't need to detain us here. The scheme therefore quite clearly was that list 1, parliament exclusive powers, list 2, states have exclusive powers, and in terms of the concurrent list, both have the power. But if what Parliament legislates is contrary to what the state legislates, or if what state has legislated is in a manner repugnant to what the center or the Parliament has legislated, then the Parliament legislation would prevail and effectively the state would abate. This was the general scheme. As we came to 246A, which was specially brought in under the 101st Amendment, for the purposes of facilitating the GST to come in, we now had a situation that in case of interstate, it would be only the Parliament which has the exclusive power. But by a process of elimination, therefore, as far as intrastate transactions were concerned, both the center, that is the Parliament, and the legislature of the states had a right to legislate. Now, the practical manifestation of this was what? The CGST laws were drawn up by Parliament. Those were then literally in a mirror image reflected as the SGST laws, and the legislature of each state passed that. So we effectively got a CGST and a SGST, which were in paramateria. In fact, they were mirror reflections of each other. The IGST adopted from the CGST whatever was necessary, but given that it dealt with interstate and international transactions, being interstate transactions, we had special provisions in the context of imports, export, place of supply, etc. So that's the framework that we got. Given the fact that states were in a way ceding some of their taxing powers, center was effectively coming into a new sharing mechanism. The framers all thought it important to legislatively also sanctify the GST Council. And therefore, Article 279A and within 279A, sub 4 provides that the GST Council can make recommendations on a series of issues, including taxability rate, etc. And sub 6 of 279A says that the GST Council, when it is acting, will be cognizant and will work towards ensuring that we have a harmonized national market. And that was, again, a very important aspect of ensuring that unless we had some body which had constitutional sanction, where states and centers sat together, and we were seeing sort of cooperative federalism sort of play out on a day-to-day basis, then it was very, very necessary that that council, which had in that manner the constitutional sanction, did have a role to be able to form consensus between the center and the state, so that the overall mission, which is one nation, one tax, one market, could actually be achieved. So this is the structure that we are familiar with, which sort of went in for the consideration of the Honorable Supreme Court. And if we now see some of the key issues on the GST Council and whether its recommendations are binding or not. And I'm going to not really now try and go through point by point on these next 9 slides, which all of you may separately want to consider. I'm going to take some very, very specific issues and deal with them, referring to paragraphs of the judgment. And I think in the context of the GST Council and what is now the role which the different provisions play, and how do we understand Article 246A in the context of the powers of the center and the state as regards intrastate transactions. Now, if we see paragraph 30 of this judgment, they regard the occurrence of these powers vested in the Parliament and in the state legislature as concurrent powers. And in the analysis that is made by the Honorable Bench, they then go on to term these as simultaneous powers. And when we talk of these as being concurrent or as being simultaneous, few questions would naturally arise. If these are concurrent and if these are simultaneous, what would be the situations of their exercise and how are those different situations accommodated for? So one situation is that while there is a concurrent or simultaneous power, it is exercised in unison. That means there is complete understanding, there is complete agreement between the parliament, the state legislatures, and they, through unison, jointly legislate a equivalent set of provisions, which is really what we've seen in the CGST and SGST, that they have simultaneously exercised their powers to achieve an identical set of provisions. I think when it goes that far, we are all in a good space. The next question to ask is, what if they do not achieve this sort of consensus? What if they do not achieve this level of agreement? And just to sort of illustrate that, what of a situation where the state decides that on a provision, it wants to legislate differently from the parliament? To complicate that even further, what if more than one state decides that it wants to legislate differently from the parliament? And therefore, states inter se are also not ad idem. Each state is also saying that I want my own variation. And what if this variation went to an aspect besides the provisions of law to another aspect of the taxation, for example, the rate of tax? Let us say that in the structure that we talk about, when we refer to an 18% levy in the context of intrastate, we are quite clear that it's 9% IGST, it's 9% SGST. What if a state said that in the context of product X, Y, or Z, or service A, B, C, I want a higher rate of taxation? Is that something which is accommodated within 246 in the correct understanding of what is a concurrent power or a simultaneous power? Now, it is in that context that there are some important comments made within the judgment. And at paragraph 48, when there is a reference again to this conferred equal power and this aspect of the simultaneous power, the situation is there is a recognition that GST Council must ideally function in a harmonized manner to reach a workable fiscal model through cooperation and collaboration. So what it seems to suggest is that while there is this ability to simultaneously legislate, but the risk that you will legislate in different directions is in a way sought to be mitigated by the council playing the role that is envisaged for it, which is to ensure that there will be harmony and that there will be a workable fiscal model in which there will be cooperation and collaboration. Now, when we talk of collaboration, when we talk of cooperation, and when we talk of harmony, inherent to my mind in all of those is a lack of divergence in how those simultaneous powers are exercised. Because if we have to, through the council, achieve cooperation, collaboration, and harmony, then really what we are saying is that while the powers exist, the powers being simultaneous or concurrent powers, they ought not to be so exercised that they will drive things into opposite directions. Now, within this, again, there is this one situation which is addressed to an argument which I think was posed by the bench to itself, to say that can we take it that a recommendation of the GST Council, which recommendation is of course directed to the union or the states under Article 279, that must necessarily be regarded as being the law itself. That can we therefore take it that a recommendation of the GST Council, given its constitutional sanctity, must automatically be taken as something which transforms into legislation. The court rightly says that is not the understanding that we can have. The council is undoubtedly recommendatory. And if it is recommendatory, I think there must be an acceptance that a recommendation may not be accepted. But while a recommendation is not accepted, the much higher argument that once recommended, steps must be taken to convert it into law, or an even higher argument that the recommendation itself is law, those have been squarely negatived. The recommendation is not law. The recommendation must not necessarily and inevitably become law. And it does not, in that manner, transform into legislation. The question then is, within the wide powers of the GST Council, is there a distinction between recommendation and recommendation? And this is again something that they go into to say that there is a wide array of powers. This wide array of powers includes those situations where recommendations are made for the state legislature or the parliament to exercise their rule-making powers. Such recommendations which are made to aid in the exercise of the rule-making powers, those recommendations must be followed, and those recommendations must be given effect to, because those are essential to the formation of the rules, which in turn are essential to fully bring alive the enactment in all its aspects. But there could be recommendations other than recommendations on the aspect of the exercise of the rule-making powers. Now, those recommendations, which are other than in the exercise of the rule-making powers, the court analyzes are not those which are binding. Those may be ignored, while those which are in the exercise of the rule-making powers, those recommendations, the court believes, must be regarded as having a far greater binding efficacy. Those must be carried into the relevant rules. But if it is on another issue, then the court believes that those are not necessarily binding. So I think the provisions which to several of us seem to have some gaps in terms of how there would be an interplay, I think the court has sought to sort of bring this together, really to say that, one, the GST Council recommends, it does not make law. Two, of its recommendations, the ones which are in aid of the exercise of the rule-making powers, which are the statutory powers to be exercised by either the parliament or the state legislature, those would be considered binding. Other recommendations would not be binding. The powers of the state legislature vis-a-vis the parliament are effectively simultaneous powers, but these powers really, under the watch of the GST Council, must be exercised in a manner which is cooperative, collaborative, and brings about a harmonized national market. And to that extent, while we recognize that there is a power, the exercise of that power is in a manner directed and expected to be so exercised that you still achieve collaboration, you achieve cooperation, and you achieve harmonized results. So the one line of opinion which seems to have emerged after this judgment, to say that in some way, this judgment is a license to say that states may legislate how they like, center may legislate how it likes, and everybody has the power to sort of legislate how it wants on what is essentially a common issue. I think that is doing a grave injustice to the erudition and the scholarship which has gone into this judgment. This judgment gives the framework. I think its most acceptable and integrous interpretation. Yes, it is simultaneous power. Yes, they can be simultaneously exercised, but we should not deviate from the overarching principle of cooperation, collaboration, and harmony. So I think that, to my mind, is the correct reading of this judgment. I don't think this judgment in any way suggests that the floodgates are open for states to go and legislate on various GST issues in the manner that they want. Another interesting aspect dealt with here is the issue of extraterritorial jurisdiction and the whole aspect of nexus. And that is covered really in paragraphs 108 and 109 of this judgment. And the issue, sort of as it comes up here, is that it was said that in the context of a CIF transaction, the transporter is engaged by the foreign exporter. The transporter provides a service to the foreign exporter. The payment to the transporter is made by the foreign exporter. If this is the situation, then quite clearly, both the supplier of the service, namely the transporter, and the recipient of the service, namely the exporter, both being outside India, there cannot be an application of those provisions which are provisions which apply when the recipient is in India. And therefore, quite simply, there should not have been a levy, is the argument made by the assessees, because the entirety of the transaction was between a supplier and a recipient who were both based outside of India. Now, the honorable bench, relying on the GVK Industries judgment, sort of looks at this to say that when we talk of territoriality, it is not that India cannot legislate to cover transactions outside its territory, but those transactions then must have a clear nexus with India. And in the context of this judgment, that nexus, it is believed, is established for two reasons. One, that the destination for the supply of goods was India, and this is a destination-based tax. And because the destination of the goods is India, the statute must be considered as being broad enough to cover an event, even if it is so-called extraterritorial, because it does bear a nexus with India. And therefore, the nexus with India is created by the factor that ultimately there is an Indian importer. The goods are meant to be delivered in India, and the journey of transportation is directed to ensure that the goods come to India. On this basis, it is said that, look, there is a nexus. Based on this nexus theory, it is said that you could now regard the importer as being the recipient of the service. And that is where paragraph 119 of this judgment really goes on the basis that the ultimate benefactor of the shipping service is also the importer in India. And since the benefactor is the importer in India, therefore, the goods whose destination is India could be considered as having the nexus. Now, this ultimate benefactor test is one which I think would have to be very, very carefully applied over time, because this is coupled with the observation that when we think of recipient under the IGST Act, we will have to understand this not only in the context of the taxing statute, but not just by a strict application of commercial principles. We will have to sort of understand it more in the context of a more object-driven exercise. And how have they done that? In the strict commercial sense, there is no doubt that the supplier of the service is the transporter who is outside India. The recipient of the service is the exporter who is outside India. In the strict commercial sense, therefore, that is true. In the strict commercial sense, no consideration passes directly from the Indian importer to the transporter. But because the Indian importer pays for the goods and the transportation, which enables the exporter to then pay the transporter who is the service provider. Therefore, this concept of ultimate benefactor, and therefore this situation to say, look beyond the strict application of commercial principles. As I've said, this is something which has been done by some of the leading judges of the Supreme Court. The manner in which they would administer this in the facts of each case, really, I'm sure would be with a great degree of balance and delicacy. But when this is looked at an assessment level, and we start talking of, let's say, an ultimate benefactor concept, let's just talk of goods which have been subjected to testing before they come to India. Quite clearly, the goods would have been tested by a foreign laboratory at the behest of the foreign exporter. The foreign exporter would have paid the certifying laboratory. Now, these are transactions which have always been considered as outside of the geographical and territorial jurisdiction to tax. But if somebody were to come up with the ultimate benefactor hypothesis, to say that, look, ultimately it is the Indian importer who wants certified goods, and therefore he is in a manner the ultimate benefactor. And therefore we need to look beyond just the pure physical service provider, service recipient appraisal. I think this is one aspect which is likely to, over a period of time, get tested in more practical situations. And it's something that will certainly have a bearing on how future interpretations of taxable situations and taxable transactions effectively go. The recipient concept also has some mention in the context of paragraph 123. They've looked at it from the lens of Article 366, 12A, to say, see the nature of the description of the levy. Talking of goods and services, because this distinction between just goods and services, or just services, is very hard to maintain in a dynamic, evolving commercial world. It is hard to maintain. And the situation is that when you talk of the import of goods on a CIF basis, then there is in a way also inherently the import of a shipping service. And if there is an import of a shipping service, and that import is into India, then a question must be asked as to who is the recipient of this imported service. And then the answer must be that it is the Indian importer who is the recipient of this imported service. And on that basis, a view is taken that the Indian importer could be a recipient. And if a recipient, then yes, there could be a taxable supply. And if a taxable supply, then of course under 5.3 and the relevant notification, there could be effectively a provision to say that this should now be charged on a reverse charge basis. So it is in that manner that the aspect of the taxability on the pure principles of taxability was effectively looked at. There is then, of course, the other aspect in the context of where they've ultimately held that the transaction in question would not be taxable, which is their appraisal of the concept of a composite supply. And at paragraph 132 of the judgment, they very clearly go into the aspect that there is a clear definition of what is a composite supply. That composite supply in case of a CIF, and CIF is a well-known method of international trading transaction, that in such a transaction, the price of the goods, the insurance and freight are all in a manner naturally bundled together. Now, if this is composite and the levy is on a composite supply, then the relevant provisions on how you tax a composite supply under Section 8 of the CGST Act is you look at the principal supply to determine taxability, and that in such transactions, the principal supply is the supply of goods. You therefore will determine taxability or rate of tax based on what is the prescribed rate for those goods. And that is what you will apply to the entire value of the composite supply. In that manner, therefore, the element of the freight is taxed as part of the composite supply. Once that levy has occurred already, would it then be possible to treat transportation as a separate transaction of supply? And could we then separately seek to tax that? And the answer is no, we could not do that. Once it has been brought to tax as a composite supply, and that composite supply inherently includes the value of the service element also, it is the service element, isolate it and seek to make that the basis of the taxation. So very clearly on merits, they've said the tax does not apply, but the other findings in the context of nexus, territorial nexus, jurisdiction to tax in terms of that understanding of territorial nexus, the entire interplay of legislative powers between state and center under Article 246A, and the role of the GST Council under 279A. I think all of these get an exposition at an extremely high level in this judgment. And as with every judgment, over a period of time, we begin to appreciate more practical nuances of this. But in my view, the way in which that constitutional scheme has been looked at, and if I see what has then been the uproar, saying states could sort of go out and legislate on their own, they can legislate on their own. But I think there is an inherent check and balance, and that check and balance is that whole sense of collaboration, cooperation, and harmony. So while they have a right, I don't think the situation is that this is in any manner a license to say that states can go off in any direction that they want, legislate in any manner that they want, because we still have to maintain the entire edifice of the one nation, one tax, one national market situation. And I think the judgment very strongly speaks, in my view at least, in support of that. So from here, we sort of go to the other interesting judgment. And this is really the judgment in the context of secondment charges. Important to sort of, as with every judgment, to just understand the facts in which this was rendered, because really it's a precedent in those facts. But as the situation was, there was a foreign entity and an Indian entity. There is a contract of service where the foreign entity takes services from the Indian entity. That's not in contention in the judgment. There is then a situation where some employees who are on the roster of the foreign company are seconded to the Indian company, so that the service contract with the Indian company has can be better discharged using the expertise of these seconded employees. The seconded employees always remain on the roll of the foreign entity. However, for the period that they are seconded, there is a letter of employment issued to these individuals. They act under the direction and control of the Indian entity. They, in parallel, do enjoy certain social security benefits with the jurisdiction where the foreign company is. And at the end of the tenure of the secondment, they are reverted back to the foreign entity. So these are the facts. The view which was taken at the level of the tribunal was that given the employment letter during the period of the secondment, the tribunal took a view that these individuals are employees of the Indian entity, and therefore the reimbursement which is paid by the Indian entity to the foreign entity for whatever are the salaries, etc., paid to these people by that foreign entity, that particular secondment charges which were paid, which were at cost, there was no build-up, there was no markup. Tribunal took a view that in these facts, these were employees of the Indian company, and there could be no levy for manpower supply by the foreign entity to the Indian entity, and the payment of the reimbursement made by the Indian entity could not be treated as consideration. So this is what effectively came in appeal by the department before the Honorable Supreme Court. Now, the Supreme Court at paragraph 50 notices some facts which effectively weighed with the Supreme Court. One, from the perspective of operational and functional control. And it notices that when we are sort of talking about this sort of control, the fact that the secondment is made, they said, clearly indicates one thing, that for the period, even though the individuals would have been taking instructions from the Indian entity, that according to the Supreme Court, they never lost their basis as being employees of the foreign entity. Why? Because they were on the roster of the foreign entity. They were in the first instance paid by the foreign entity. Their social security benefits and related administrative activities were taken care by the foreign entity. And the Indian entity, even though they issued a letter of employment, ultimately were only given access to these employees for a limited period. Post that tenure, they reverted to the foreign entity. And the reimbursal that they made was clearly a reimbursal, the commercial significance of which was that they were then carrying out the work which was the work of the Indian entity. And since they were carrying out the work of the Indian entity and benefiting the Indian entity, it is only natural that India should reimburse, the Indian entity should reimburse. Now, in the interpretation of the contract, the Honorable Supreme Court takes a view that we must look at substance over form. And it says that this is the one test which has consistently been applied. Now, undoubtedly, the test of substance over form has been uniformly applied. At the same point in time, we are sort of all aware that there are other judgments which say that it is not for the authorities to go behind a contract. It is not for the authorities to rewrite a contract. It is not for the authorities to try and give a different meaning to the contract, different from the words which are actually used by the parties. And therefore, this issue of when we lean towards substance over form, and when we look at the contract for its language and administer it based on what parties choose to use as their language, I think this is always something which is going to be extremely circumstantial. The facts of the case are going to get a court to lean in one direction or the other. In this particular case, the view that they took is that, look, the substance of this transaction is that these employees work dedicatedly for the Indian entity while the secondment is on. At that point in time, there is a benefit that the Indian entity has from having these people. They pay for it, but these are not employees in that manner of the Indian entity. They continue for various reasons, such as their enrollment on the payroll of the foreign entity, to be employees of the foreign entity. And therefore, the transaction is a transaction of manpower supply. And being a transaction of manpower supply, the reimbursement, even though it does not have a profit element, is in fact a consideration. And this consideration is what is taxable. And the one situation, I think, where the argument comes up that, can you consider the reimbursement as a consideration? I think the court at para 58 probably, instead of looking as the consideration flowing from the so-called recipient entity, which is in India, to the foreign entity, sort of in the last few lines of para 58, says that there is an economic benefit derived by the Indian entity. And because they derive an economic benefit, therefore there is a consideration. I think somewhere in the approach, the focus probably should have been on the aspect of whether what flows from the Indian entity to the foreign entity is consideration, not vice versa. Another very important aspect which comes up here is, how is this going to impact many other types of transactions where, let us say, you have a head office and you have a branch office in India, where the employment is a common employment because everybody is employed by one organization. The head office and the branch are not two separate juridical entities. In the facts of this case, they were separate juridical entities. Each had an independent legal existence. But between a branch and a head office, that is not the situation you will have. The employment contract often will require the employee to work either at the head office or any branch all over India where they are asked to work, or in any other part of the world. Now, those sort of facts, to my mind, are necessarily different from this situation where you have two legal entities and you have a situation where there is a clear commercial contract between them. And I think it is in the facts of this particular case that the court chose the entire issue in terms of substance over form. It is in the facts of this case that the court took a view that even if it was simpliciter, a reimbursement, in the facts of this case, it still satisfied all the tests of taxability, namely supply of service, exchange of consideration, quid pro quo, etc. So while there will be, I think, some attempt by the department to apply this across the board to all situations where there is a foreign and an Indian entity, and there is some sort of interaction or interplay in terms of employees, I think it's important to appreciate that the facts are clearly different. And this is ultimately only a precedent in its facts. But certainly, if the principles here have an application, then those will have to be examined relevant to the facts of each individual case. There is also the aspect of how the Supreme Court has dealt with revenue neutrality. Let me just place this in context. Often, the argument of revenue neutrality, whether on a forward charge basis or reverse charge basis, was that ultimately, if the amount to be paid is available as a credit to the same entity, then why is there a need to pay the tax at all? And we've had judgments in the context of Coke and SRF, etc., which have taken this view, right? Where the court has said, look, ultimately, if it's revenue neutral, we don't need to thrash our heads with this. When this issue has come up to say that it is revenue neutral, therefore in a demand situation, because it's revenue neutral and I myself as the assessee get credit, I shouldn't pay tax. There have been judgments, and more recently in the ICICI judgment, again the tribunal took a view that if we say that in every situation which is revenue neutral, no tax is to be paid, then it would be completely contrary to the scheme of taxation. Because then every car manufacturer could say, why should I pay at all earlier stages? Because at some stage I'll pay later. Obviously, the contemplation of the law is each supply creates a taxable event that has to be discharged. Credit follows as a consequence if credit is permissible. The view taken here is that, look, revenue neutrality is not a consideration which is relevant. If there's a liability, you pay that liability. Now, in a manner, this runs contrary as a line to the SRF, Coke, the British Airways judgments at the tribunal level, and SRF and Coke, of course, as you know, were Supreme Court judgments. So to that extent, it takes a deviation. There is another allied line of issues that if it is revenue neutral, can the longer period of limitation apply? Because if it is revenue neutral, then there is no intent to evade. I think this judgment does not in any form or manner touch or dilute the issues that if there is revenue neutrality, longer period cannot apply. This does take a view that revenue neutrality in the context of saying no liability to this bench, that did not appear to be a relevant consideration. The aspect of revenue neutrality and what it means in the context of limitation, I think is untouched by this. Incidentally, in this case on limitation, they said that the longer period couldn't be invoked because it was interpretational and there were different viewpoints, etc. So again, on revenue neutrality, I think this strikes an important note to say that that could not be the basis to not pay the tax. However, the issue that longer period won't apply, to my mind, is still open and would still continue to have the benefit of earlier judgments and earlier precedents. So again, I think a very, very important judgment in the context of the development of the law. I now have two more judgments to cover, and those will not sort of require the amount of time that I've taken with the first two. So the next judgment to consider is really not a definitive judgment because they have not arrived at a conclusion. The case is of the Commissioner GST versus Citibank. The transaction which you are pictorially seeing is an interesting one. It's something that we do every day, which is make payments on a credit card. And if you start at the extreme left hand of this particular slide, you will see that at the top is a merchant and at the bottom on the left hand is a customer. So typically a customer who has been issued a issued a credit card by an issuing bank has the card and uses it to make purchases. So if you see where we have the box for the customer, we have a dotted line to an issuing bank. So a bank, and let us say in this case, a Citibank, issues a card to an individual who's a customer. He goes to a merchant and he swipes his card. In our example, we've shown that he buys goods worth 100 rupees. Now, that 100 rupees of goods which is bought, the merchant has a relationship with an acquiring bank. So rather than sort of waiting for the entire period for the customer to pay and the payment to get routed to the merchant is immediately able to realize a discounted merchant price, or what is called the merchant discounting rate. He is able to get a sum of money upfront. In this case, we've illustrated that on the 100 rupees of goods he had sold, he receives 97. And the merchant discounting rate is 3 rupees. Now this 3 rupees is 3 rupees on which the acquiring bank pays the appropriate service tax. Then this acquiring bank and issuing bank effectively deal with each other through a card network, whether it is MasterCard or Visa or whatever, where hundreds of thousands of transactions are settled and then net amounts are paid by each other to different acquiring and issuing banks. Now, in this whole process, what happens is the acquiring bank, which has acquired the transaction at 97, and therefore, in a way, has 3 rupees as the discount margin, pays tax on it. In turn, what happens is that the issuing bank, when it recovers the 100 rupees from the customer, pays 99 to the card network. The card network in turn pays the acquiring bank. And just to simplify things, if the issuing bank pays 99 rupees, it has got 1 rupee for itself. If the card network keeps 1 rupee, then 98 is what will be paid to the acquiring bank. And if we contrast the 98 of the acquiring bank vis-a-vis the 97 it paid, they also get 1 rupee. Now, the question really was that the 1 rupee, which is the 1 rupee charged in a manner or retained by the issuing bank, is called an interchange fee. And the issue was whether this will be liable to tax or will not be liable to tax. The two honorable judges framed various questions, and we've then made an analysis of the decision in terms of the different aspects of that. Now, what is critical for me is really the aspect that while the two learned judges did agree on several issues, and our analysis shows that, it's important to maybe go over the page to see where is it that they actually differed. Now, the key point where they differed is whether the assessee is liable to pay. Assessee here being Citibank, the issuing bank, is liable to pay tax on the interchange fee, that 1 rupee we talked of, and not only pay the tax, but also file its service tax returns. Justice Joseph took a view that service tax is a value-added tax. And from that perspective, it would only mean that for separate services, tax must be paid at each point of rendition of service. Therefore, even though tax may have been paid on the 3 rupees, of which this 1 rupee is a subset, you still have to pay tax on this 1 rupee. Justice Ravindra Bhatt, on the other hand, took a view very clearly that you cannot go around slicing and dicing each of these transactions. That for the transaction, the difference between the price of the goods sold and the amount realized by the merchant, goods sold at 100, price realization of the merchant 97, the 3 rupees have already discharged tax. That 3 rupees is in a manner a reflection of what everybody involved in supporting the credit card transaction will get some part of. The issuing bank will get something, the acquiring bank will get something, the card network will get something, but all of those are subsets of the 3 rupees. And therefore, if the 3 rupees is taxed, each part of the subset of the 3 rupees ought not to be taxed. And this is where the two honorable judges differed. On the next page, they differed on another issue, which is the invocation of the longer period. They both believe that longer period ought not to be invoked. Justice Joseph said that there ought to be a remand on this for the SESTAT to consider. Justice Bhatt believed that there was a long history of communications, correspondence with the CBIC led by the Indian Banks Association. The facts were well known, and therefore there can be no question of willful suppression. And in that manner, his situation was no need for a remand, a longer period of limitation won't apply. However, given the divergence in the view on merits, the matter now the Honorable Chief Justice will designate another bench. Currently, it's supposed to come up on the 12th of July, 22. But again, for me, this judgment offers a interesting insight into the aspect of composite, non-composite, individual elements versus composite elements. You know, somewhere we are seeing a view that if it is composite, you cannot sever it. Somewhere we are seeing a view that, look, if required, you go ahead and sever it because every event should be taxable. And I think over the next few months, there will be a certain level of synergy which sort of draws as the judges sort of all commonly come to appreciate also the views which are being taken in other judgments. Let me go finally to a interesting judgment of the Gujarat High Court, which is in the context of a situation where an individual contracted for buying land and also the construction of a bungalow. And as we know, a pure transaction in the sale of land is something which is not taxable under the GST regime. And the situation then was that under serial number 3 of this notification 11 of 2017, a basis of sort of levy came about where it was said that 18% is to be paid on the construction service. But on a deeming or hypothetical basis, it was decided that 1/3 should be considered as the land value. That would be out of the tax net. And the remaining 2/3 would get taxed at 18%. Therefore, in effect, it was being said that the construction services would be 2/3 and the land would only be 1/3. This effectively came up for challenge. And as it came up for challenge, the Honorable Gujarat High Court examined a series of 4 issues. They went into the legislative intent for imposing tax on construction activity. They went into a situation that if the actual land value was available, would it not be obligated to consider that rather than some presumptive basis? It went into whether the notification which presumed a 1/3 value was arbitrary, and went into whether there was legislative competence for the promulgation of such a notification. Some very, very interesting findings. Firstly, the view which was effectively taken is the legislative intent is very, very clear. Schedule 3 lists what is not taxable to GST. Schedule 3 said sale of land is not liable to GST. If that is so, then directly, indirectly, you cannot bring any part of the value of land to tax. And therefore, taking a guidance from Schedule 3, which is to do with the charging section, the view was that directly, indirectly, you should not have any mechanism which taxes the value of land. Question that came up is that if in a transaction like the one under consideration, the value of land was separately known, construction cost was separately known, which did not come and fit into this 2/3, 1/3, but those values were known, then consistent with the charging provision and the valuation provision, the value ascribable to construction alone should have been isolated. That alone should have been taxed. And given the bar to taxing a transaction in sale of land, the value of the land should have been kept away. The issue that, look, people could overstate the value of land, etc., they said that cannot define the taxation principle of taxation. If somebody is making an unfair disclosure, you have other means and methods to correct it. But you cannot form a basis of taxation which seeks to tax indirectly something which Schedule 3 specifically keeps out of the tax net. The other aspect which sort of came up was, is this particular notification ultra vires or not? Now, two very important approaches which were taken. One, it was said that you apply this 1/3 uniformly, irrespective of the size of the plot, the location of the plot, the complexity of the construction activity or its simplicity. Therefore, this is an ad hoc and arbitrary basis, right? The other view which was effectively taken is that if you have to bring about any change in the basis or adopt a presumptive mechanism, it is to be done only by the modality of the rules. It cannot be done through a delegated legislation in the instrument of a notification. So what is permitted is that you legislate rules. What is not permitted is you bring such a provision through a notification. And it said that even if I go on the basis that there is a competence to bring about such a provision, although the judge was of the view that there was no such competence because it was done by notification, not rule. But he says, even if I assume there is a competence, it can still be struck down on the basis that it is arbitrary and it is contrary to the scheme of taxation in the statute. So this, again, I think, important judgment not only impacts the real estate industry, clearly also impacts other industry like the solar industry, because there again we have some presumptive mechanisms of valuation in terms of what is to be presumed. Quite clearly, that also would not stand scrutiny in terms of the principles adopted here. And judgment by Justice Pardiwala, who, as we've all read, has now been elevated to the Supreme Court. So I think from that perspective, in the last few weeks, we've had a very exciting array of judgments which are intellectually stimulating, certainly will have a much wider impact. Some of them have stirred a bit of a political hornet's nest. But as we see, the law has gone forwards. Some challenges arise, some issues are now quelled. And all one can say is, given the history of litigation in our country, these 4 judgments will sort of leave their own mark. But soon enough, we'll have another 4 that we will all want to discuss. And from time to time, some of the issues here will pass into seminal law. Some of these issues will get revisited. But for the moment, this is the mind of the Supreme Court. This is the mind of the Ahmedabad High Court. And I thank Arun for this opportunity for me to share my thoughts and views on this with all of you. Many thanks.
Yeah, Rohan bhai, I know you're extremely short of time now. We've run out of time, in fact. But I just thought thanks for that exposition, Rohan bhai. I don't need to mention that and labor that absolute exposition on these judgments. It's always exciting to hear you speak. You must have seen I've changed my jersey. I'm already in the cricket mode. Lucknow versus RCB. Whom are you rooting for? Who's your favorite player? Hey, Virat is going to definitely deliver.
Yeah, it's pretty public. I'm on the board of Rajasthan Royals, so I have no conflict of interest.
We'll see. We'll see. This is going to be an interesting IPL. Everyone, we have another webinar coming up on Friday by Additional Solicitor General N. Venkataraman on the ocean freight issue. So do join in for that as well. And wishing everyone a fun-filled IPL week ahead. We know whom Rohan bhai is rooting for sure. The cricketer in him is still as young as the 18-year-old or 19-year-old who played for Pudar College alongside Ravi Shastri.
Thank you. Thank you.